Hello everybody. When you guys get around to watching the video, by all means listen to what I have to say. Sorry I don't have a cam here for you to look at to see my face, but I honestly don't have one. And I'll apologize in advance. I have a bit of a cold, so if you'll bear with me. A lot of questions. I've talked to a lot of single parents, especially single dads, and being from Ontario, the legal system that we have is just a joke, to say the least. And I have to say that what do you do in a situation where you have no protection when you walk into a courtroom, and I don't know, let's say you're a self-litigant, right? A lot of people are self-litigants. Myself, I'm a self-litigant. So if I will go in the courtroom and I'm defending myself. I'm trying to defend my child. I'm there to mean business. I'm not there to play games. I'm there to deal with the issues at hand and try to address them as best I can, right? And you're before the court and you've got your case and you're making your argument, and then you swear when you walk out of that courtroom that judge has got it out for you. Like, just making ridiculous orders, ridiculous decisions that don't add up. To you, it seems, okay, well, this is not acceptable. This is not appropriate. This is not this. This is not that. It doesn't make sense, right? I'll give you, for instance, a lot of families are victims of the Children's Aid, okay? And the Children's Aid will make an allegation. And there's no evidence at all. It's just their word against yours. And the judge will immediately make an order in their favor, right? And you're like, how the heck does that happen? Well, it's because judge's bias. The law actually tells you that they can't do that. Okay, so on the topic of Children's Aid, they're actually not allowed to do that. They're supposed to file their application and provide supporting documentation to prove that there was a child safety risk. In fact, if you really dive into it, they technically are supposed to have police involved or some kind of medical professional involved. They're not allowed to make the claims themselves and consider themselves as professionals. That's becomes judge, jury, and executioner. They're not allowed to do that. That's against their constitutional rights. So they're actually not allowed to do that. They absolutely have to bring supporting evidence. Now, if you're against your ex and you're in a divorce case or a custody case, fighting for your child, you'll notice that the woman, if you're a guy, that the woman is almost taken at face value, right? But the guy, and I guarantee any dads watching this right now are shaking their heads like, yep, But then the guy, it's like, oh, but you need to provide more evidence. Especially when you get a female judge. I've had three of them, yeah. I shake my head. I'm like, either you're sexist or you're dumb as a doormat. I mean, either one, right? Making decisions like that without, following through. So, again, you look at that and you're like, whoa, what is this judge thinking? What is it? Is this judge on drugs? That's what you're thinking, right? You're thinking like, what the flippin' hell is going on in this courtroom right now? And so, what do? Well, here's the thing. How do you know if the judge is biased? Because that's the first thing. You cannot defend yourself unless you know the situation. And I don't mean your documents. I don't mean your case. I mean dealing with the judge, with the court. What is your situation at the court? What are you up against, right? Who are you dealing with? What's their background? Things like that, right? You want to look that stuff up. Look the judges up. It's public information. So if you want to know if that judge is biased and discriminatory against you, then there's only one way to know that. Well, technically there's more than one, but it really boils down to the behavior of the judge, right? That's what it boils. If you sum it all up, it all boils down to the behavior of the judge. What is the judge telling you? I'll give you some examples from my own case, okay? Completely ridiculous. I mean, to the point of a Where's Waldo book looks like a genius in comparison to the decisions the judge in my case has been making. Okay? So let me give you an example. I go to case conference, right? And I did a motion to change because the CAS completely destroyed our lives. I bring it to court. I tried an appeal that got botched. I bring it to the family court and say, listen, like, this is ridiculous. The Attorney General's office got involved, for goodness sake. Like, put it back to the appeal stage, right? Or bring it back to the trial stage of the CAS matter and order the CAS to produce the file so that we can actually adequately and meaningfully fight the issues, right? Judge doesn't want to do it. First of all, says I don't have jurisdiction to provide the report or the file, or I'm just not going to. Well, hold on a second. Yes, you do. They're making an argument. They need to provide that file because we need to see what's in that to see if what they're saying is true, especially from an agency who tells nothing but lies, right? So the first thing is, judge won't do that. She's a former defense lawyer for the Children's Aid, so of course she's not going to do that. She'd be getting herself in trouble if she did that. So, okay, fine. You're not going to do that. Well, what about the trial stage? Okay? Because during the trial, they'll have to produce the file, right? And plus, there's time anyway to get the file, from the time once it's decided that it's going to go back to trial stage. But she's like, nope, and she's the former trial judge for that actual case. So, okay, bring it back to the trial stage then. It's within your jurisdiction. She says, no, it's not. So I'm like, fine then. Bring it back to the appeals, like the actual appeal stage. Okay, it was botched due to clerk, at the clerk level. It was proven. Attorney General's office got involved. The whole table met. The works. Lots of evidence to support that I'm right. And this was her response. Okay, this is the kicker. Sorry, taking a swig here. This is what she said to me. How did she word it exactly? She said, I cannot be expected to order a higher court to take a case. I'm under them. I cannot do that. That's what she said. Well, hold on a second. All right. When I went into that hearing, I was well prepared. I knew my rights before I walked in the doors. In fact, I knew my rights before I even filed the initial application. So I already knew that I was right. The rules are, just like in any situation, it doesn't matter if it's in legal, if it's in friggin' restaurant, it doesn't matter, okay? When you have a level where you're at a level and you're saying, and that level is saying, I can't help you, they have to escalate it to the next level. This has nothing to do with making a court order. You don't order the higher court. It's simply saying to the higher court, I don't have jurisdiction here. You need to take this matter because it belongs in your court. And here's why. And that's it. And the other court will go, yay or nay, right? Either we agree or we don't agree. And they'll look at that. That's how it's done, right? That's the simple process. When you break it down in the law, that's what it breaks down to. That's exactly how they do it. The judge simply writes a document that goes off to the other court and says, this matter belongs in your court, right? Then you go, and then they decide whether or not they actually want to keep it or not. Or if they feel that the other court, the previous court, actually did have the jurisdiction. In which case, then you go back to the previous court, and the previous court goes, oh, according to the order from this court, I got to deal with it this way. You know what I mean? That's how it's done. The lower court doesn't order the higher court. It simply says to the higher court, I can't do this. This belongs to you. Well, what reason would the judge have to say what she said to me? Well, I can tell you the answer to that. It's because she was trying to divert the issue and keep it where it was so that I couldn't get the situation resolved. If I had it in the Court of Appeals, I would have won hands down. But she wanted to keep it from the Court of Appeals. Had I known the right wording to use that day and had a copy of the laws on me, like physically in my hand, and, and all that, and some case law, I could have given that to her, and she would have been forced to do what I asked her to do. But because I wasn't as prepared, I didn't think I needed to be prepared in that way, but that's what it turns out to be. So remember that lesson. When you go to family court, okay, and a judge, you're making any argument, be prepared the judge is going to give you the finger, okay? Theoretically, well, not theoretically. What's the word I'm looking for now? Wow. Anyway, just be prepared for the judge to, kick you in the pants. So what you do there is you say, okay, well, my argument is this, and here is, and when he or she says, oh, I can't do that for this reason, then you produce the law. You don't attach it to your paperwork. You just bring it with you. And you go, well, but I've got it right here, Judge. It says the following. Under this section, this section, And I did some checking because I'm not a lawyer, so I went on canley.org and I got some case law, and right here on page blah blah blah, paragraph blah blah blah, it says blah 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 blah. And this is from the following judge in the following case. And then and then the judge, it has no choice. Especially if that decision was made by a higher court. So if you get a higher, I just realized my microphone's going like crazy here. So if you have a higher court that you're dealing with, if the court is higher than the court you're in, they actually have to abide by that order or that case law, because that is above them, right? So that's how you know, because the judge is going to make any excuse in the book if they want to support the other parties. They're going to do everything in their power to support the others, and when that happens, that's how you know, right? But you don't wait forever. You put the judge in a place where they have to defend. Another issue that I've noticed too is trying to find my microphone setting out here. This is actually not the tab I wanted. I have no idea if this is turning it down. Yeah, it is. Okay. Put it to 75. Okay, so excuse me. Testing 1 2. Testing 1 2. I don't know. Okay, so when it comes to the family court judges, if they're, one of the other things I noticed was, in my case, they'll deliberate when making a decision on a minor issue. I think I'm coming in too quiet now. And so, yeah, you know what? I think I was just talking loud. Okay, so at the end of the day, you're trying to, do the right thing. And then, of course, the court's going to say, well, everything we do is in the best interest of the child. Well, I can't help but laugh. I've openly laughed in the courtroom at that. I completely just started laughing. I couldn't help it. And it wasn't because I thought it was funny. It's just because I was disgusted. I'm like, you've got to be joking. You honestly, you've convinced yourself of this? And it's like, no, the best interest of the child is furthest from the judge's mind. They don't give a squat. They don't give nothing about those kids. They don't care. They care about their paycheck, right? And so that's what they want. That's what they care about. If you handed a judge, and I'm not saying that I suggest this, I'm just saying, for argument's sake, if you handed a judge $50,000 and said, make sure I get custody, that judge will rear end every other party that you're against. Automatically. Of course they will. You give them 50 grand. Okay? So, but if you're someone who's low income, okay, because you hear it all the time, if you don't have the money to defend yourself, then the judge ain't going to care, right? You're going to get screwed. You're going to get railroaded. If you're stuck with legal aid lawyers, you're going to get railroaded. I've experienced that, because they don't get paid enough to do a good job. So, again, if you don't have the money, they don't care about you. It's all about the money. And cases like the Children's Aid, for example, they make a considerable amount of money for the courts. They backlog the courts so bad they got to hire more lawyers, more judges, more everything, more court staff, and it's pretty ridiculous. So I don't know what else to suggest. I mean, when it comes to identifying if a judge hates your guts, at the end of the day, it's going to boil down to the judge's behavior. Okay? Are they going to take your word for it? Are they ignoring evidence and finding excuses or technicalities to not look at your evidence? And when they make an order against you, do they deliberate and then come back to you, 10 days later, 2 weeks later, a week later, whatever, and then they provide case law as to why they made the decision that they made? Because you catch that kind of nonsense. It's like, really? Especially for a minor hearing. It's one thing if it's a trial, and the judge has got to deliberate to make a decision after doing the trial. But over a minor hearing, you don't need to deliberate for 10 days or 2 weeks or hand it off to another judge or whatever. Are you kidding me? No. You're getting paid a couple $1,000s to do this for the day. The least you can do is finish the order right there in the courtroom. You know what I'm saying? You don't know what's going on behind the scenes when they pull that crap. So, for all you know, they're giving them a campaign donation, or they're, the judge got bought off, or something. You know what I mean? Like, yeah, how do you know? So, it's when a judge is deliberately making decisions against you, is ignoring your evidence, is making excuses, okay, to try to cover it up, basically taking advantage of your lack of knowledge, okay, that's how you know they're biased. That's what it boils down to, okay. I suggest in those situations to essentially make the judge prove it, okay, because when you go into the courtroom and you got your evidence and you've got your copies of the law and case law and everything in your hand, and you're saying, okay, this is my argument for the following reason, right? You make your case, and the judge will make some excuses as to why, and then you produce more, right? Which is law, case law, whatever. Judge will make some lame brain excuse as to why, or that you're misinterpreting it, or whatever the case may be. But no, you're not, right? And so you're simply saying, no, this is not the case. And if you think it is, if what you think is correct, then I challenge, then I insist that you prove it. Prove it to me. Show me case law. Show me actual law. Show me where it says I can't do, or you can't do what it is you're saying you can't do. Whatever the argument happens to be, make them prove it to you, because they have to. They can't just go, well, I don't have time for that. Well, you're going to make the time because you're in court. You're the adjudicator for this matter. Make the time. If you need a 1 hour recess to look it up, then fine, we'll have a 1 hour recess. But we come back into this courtroom and you're going to have an answer, right? So it's they get paid a crap ton of money. I mean, you can bloody well look it up. As a judge, they're a trained lawyer. They have no excuse to not know the law. It shouldn't take them a 1 hour recess to dig something up. They should be able to say, well, here's the act and this is what it says. Okay, well then produce some case law, show me. Because as it stands right now, my case law says different. Right? And that's how you succeed. Essentially forcing the judge to say, make the order in your favor by saying, look, I've done my homework. Prove to me that you're right, and then I'm not. And they can't. They never can. So they might find some way to manipulate things or whatever, but at the end of the day, as long as you put enough in them, they overwhelm them with evidence, like overwhelming evidence, not like little bits of crap. Because nobody cares about little bits of crap. Not even the court cares about the little stuff. Which is another issue. You're in family court and you're talking about, oh, he said this and she said that and da-da-da-da. Really? You really think the judge cares about your personal arguments? Whether or not you were getting laid? Whether or not you didn't like the clothes they were wearing? Or the fact that they smoked cigarettes? Or whether or not they cleaned their bedroom? Or did the dishes regularly? Do you really think the court cares? No, they don't. Okay? What they care about, what they're supposed to care about, is how to best solve the problem. And if you're being nasty, vicious, vindictive, attacking your ex or whoever the case may be, whatever the case may be, then you're being vicious, and then the judge shouldn't like that, right? And you got to remember that you got to be reasonable, right, within the law. Now, if you've got a concern and say maybe it's not been something that's proven, but you know it to be a fact, you can honestly say to the judge, listen, Mom was, abusive, and this is what happened, and I understand that I don't have evidence to support it, but it would not be appropriate, lawfully or even morally, to put the kids in that situation, with unsupervised access, until at least there's a proper assessment or follow through to verify that the mom has received, diagnosis, some medication, whether or not there was a police investigation, whatever your case requires. So at least that way, when you make your argument, you're not saying no, you're saying no today because there's concerns that have not been addressed, whether the CAS hasn't addressed them, whether the court didn't follow through, because you can even say, like, look, I've asked for this and the court hasn't followed through. You need to do this. How is it in the best interest of the child to not check to make sure that I'm, that this is not an issue, right? And so, you got to kind of just keep leaning it back in that direction and go, look, no, you need to do this. For dads who are being alienated, it really boils down to, look, I mean, Look at what mom's doing. Mom's not letting me see my kid. How is that in the best interest of my child? Right? And if you don't have a court order, here's another piece. I'll leave you with this before I log off here because I got to leave soon. But you got a court order and mom's not letting you see your kid. Okay. I totally lost my train of thought there. What was I saying? I don't even remember what I was going to say now. I completely lost my thought. Thanks to this cold. Anyway, the when you're not being granted your access and you've got, or sorry, I remember now. I apologize. Okay, so when you don't have a court order, okay, so you've just separated, you don't have a court order. You've got to go back to the Children's Law Reform Act. Section, I keep saying section 21, but I don't think it's 21. I think it's 24. I'm pretty sure it's 24. Let me take a look. It's the Children's Law Reform Act. Let's take a look on here. Children's Law Reform Act, Ontario. Canley. Because I don't like these other sites. They suck. Yeah, okay, here we go. So, Canley, link to the latest version, whatever. Okay. No, it is the same thing. Okay. It was section, I'm pretty sure it was section 24. See, this is, I don't think it was 21. No, 21 is the application. Okay. So I think it's 20. Yeah, here it is right here. Yeah, right here. 24. 24-2. Best interest of the child. Okay. So the best interest of the child is that when you separate, you have joint custody of your kid. Automatically. Like legislation requires it. Okay. So, and actually I don't think it's 24 that actually says that. I think it's serious harm. It's under the, man. This is the, yeah, 24 is the best interest of the child. Where is it here? Maybe it is. Maybe I had them confused. Maybe I was thinking 21 is the spot I was actually meaning to talk about. Entitlement to custody. Here we go. Yeah, here it is right here. Section 20, entitlement to custody. So I apologize. I was thinking of one thing and saying another. All right. Except as otherwise provided in this part, a child's parents are equally entitled to custody of the child. Now, I want you to remember that line, okay? That is incredibly important. Okay? 20.1 and 20.2, this is incredibly critical in a custody matter. All right? You are equally entitled on separation. The mom can't do anything without you, and you can't do anything without them. Now, there is no court order, so therefore, you are in the right. There's nothing to stop you from picking up your kid from anywhere. If mom's saying, I'm not going to let you see your child, okay, then go to the school. Pick your kid up from school. Nothing wrong with that. You've got full rights under the legislation. Nothing they can do. They want to call the cops, let them. You're not going to jail. You didn't do anything. Kid's still going with you. Nothing they can do. Nothing. Nothing the mom can do. Nothing the police can do. Nothing. It's completely legit. You can do what you want. Right? And so that's there for a reason, because that's there to get parents to work together. Right? And put the child's best interest at heart. Okay? So that's what that's for. And you have those rights. And until you walk into the courtroom, okay, and I want to stress that if you're thinking about going to court, be careful. Courts are not there to help you. They're there to make money. And they will do it off the misery of you and your kids. And they won't think twice about it. And they have no remorse over it either. Okay? So remember, use this section, work out your own agreement. You can have your own little agreement. And you guys just stick to it and don't be vicious to each other and work it stuff out. Okay? But when you're dealing with stuff like the Children's Aid Society and you're dealing with, vindictive exes and stuff like that, remember, at that point you need to focus on wherever the law helps you. So in this case, entitlement to custody if you don't have a court order. Okay? And I wouldn't quote that to the ex who's doing it. Don't even quote it. You don't have to. You don't have to tell them. Don't tell them anything. Okay? It's you have a right to your kid. It doesn't mean you go slamming in their door and going, I have a right to it because this guy said on YouTube. No, it doesn't work like that. Okay, you go to the either in school or in daycare. You show up to wherever they happen to be and go pick your kid up. Okay, they're gonna call the police. Let them. And then you say to the cop, I'm just here to see my kid. You know, I have an entitlement to rights, entitlement to custody of my child per the legislation. So, you know, it is what it is. I'm here to see my kid. Mom's being, you know, vicious, and I have an entitlement to custody of my child. And if mom's going to, you know, not going to be cooperative, then we may have to go to court to get it resolved. But I'm here to pick up my kid, and that's what I'm doing. Have a nice day. And that's it. Nothing they can do. So, you know, and they'll walk out. They'll just be like, yeah, they'll tell the mom. He can do what he wants. He can completely do what he wants. You know, you have to take it to the courts and deal with them. That's what they're going to tell her. And then you decide how you want to handle that. You know? Because once you leave the child alone, then they have the right to come back and take the child. But if the child's physically with you, they can't just walk out with the kid. Right? So that's how you use that. Be like, nah, mom's being vicious. Okay, you know what? All right, mom, you want to see your kid? You're going to do it here under my supervision because I don't trust you right now until we get to court and we can get it resolved. Right? But that's only if there's a good enough reason. Don't do that for no reason. Don't do that because you just want to be a dick. Or do that because you feel that your ex is vicious. Okay? There's a point when it's okay and a point when it's not. All right? So be smart about when you choose to do what and how you choose to do what. But if mom is absolutely just being a pain and not letting you see your kid, and you finally get your kid and the mother's just causing trouble, then it's oftentimes it's in the child's best interest at that point to hold on to the kid and go, look, you know what? We don't have a court order in place. Kid's staying with me. If you want to see the child, you have to come here. You know, I can't trust you because you'll just take off. And, you know, whatever. Or you just don't let them see the kid until you file your court documents. That does not mean that you have an excuse to wait months to do it. It doesn't work like that. And it's harmful to the child. But what you can do is you time it properly. You get your kid. You do the paperwork. Then you file the paperwork. And then you tell mom, okay, well, you can come see your child, blah, blah, blah. You know, here, mother doesn't want to do it. Okay, make sure that you recorded that because mom's going to be like, well, F you, I'm not coming to your house, and that's not how I have to do things, blah, 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 blah. And okay, well, mom obviously has no interest in seeing the child. Okay, here's the proof. And you've got it made, you know, because now at that point it's like, well, look, you know, you were not letting me see my kid. You know, I've got my kid now. My kid's fed, you know, clothed, has a roof over their head, shoes on their feet. You know, here's the situation, you know, and mom's been very, you know, controlling and whatever, and this is the situation. This is what I did. I acted within my rights under the law, and I did what was best for my child, and I've offered mom access, and mom won't do it because she doesn't want to come to my house. Well, obviously she doesn't want to be involved in the child's life. I'd like sole custody. And that's it. I mean, it's behavior, right? Because the judge is not supposed to be biased, okay? When you get a decent judge, that kind of an argument will go fast. You don't have to give them a bunch of crap. It's just bottom line, this is what you're saying. They don't care about all the little things. This is the bottom line. You're saying the following, right? So anyway, that's how it is. I'm going to log off now. I hope this helped. Maybe it didn't. Maybe I rambled on for no reason. I don't know. But I was kind of wanting to share some knowledge. But anyway, it is what it is. Okay, so I'm going to go. And I wish you guys all the best.